Okay, it's 7 p.m. If everybody's ready, I think we should begin. Okay, good evening, everyone. At this time, I'd like to call the meeting to order. Today is Thursday, January 26, 2023, and this is a meeting of the Rent Stabilization Commission for the City of West Hollywood. We would like to begin by acknowledging that the land on which we gather, currently known as the City of West Hollywood, is the occupied unceded seized territory of the Gabrielino Tongva and Gabrielino Kizh peoples. All right, Commissioner Martz, would you lead us in the Pledge of Allegiance?
Absolutely.
Thank you.
All right. I pledge allegiance
Pledge allegiance
to the
to
flag
the flag
of the United
of the
States
United States of America,
and to the
and to
republic,
the republic for which it stands,
one
one
nation,
nation,
under God,
under God,
indivisible,
indivisible,
with
with
liberty
and justice for all.
Thank you, commissioners.
Thank
All
you.
right. Ms. Secretary, may we have a roll call, please?
Yes. Commissioner Kirpies,
Present.
Commissioner Maggio,
President.
Commissioner Martz,
Present.
Commissioner Wright,
Present.
Vice Chair Ayers will be absent for tonight. Chair Topshin.
Here, we have a quorum. Thank you very much.
Mhm.
And the approval of agenda is our next item. Item number 4, commissioners, do we have any motion regarding the agenda?
Motion to approve.
Second.
All right, we have a motion and a second to approve the agenda. Ms. Secretary, can we have a roll call vote?
Commissioner Kirpies,
Aye.
Commissioner Maggio,
Aye.
Commissioner Martz,
Aye.
Commissioner Wright,
Yes.
Chair Topshin.
Aye, agenda is approved. Thank you. Next item is number 5, approval of minutes. We have the minutes of the meeting on, what was the date? January 12th, 2023, the Rent Stabilization Commission meeting. Has everybody had a chance to review the minutes? If yes, if we have a motion.
I'll make a motion to approve the minutes of January 12th, 2023.
I'll
Second.
second it. Okay, Commissioner Wright seconded. We have a motion and we have a second. Ms. Secretary, may we have a roll call vote?
Commissioner Kirpies,
Aye.
Commissioner Maggio,
Aye.
Commissioner Martz,
Abstain. I was absent.
Commissioner Wright,
Abstain. I was absent.
Chair Topshin.
Aye. So, well, we have 3, we still can approve it, right? Although we have 3 votes, yes. So the minutes are approved. Thank you. Next is public comments. Ms. Secretary, do we have any speakers at this time?
No speakers at this time.
All right, no public comments, and we're moving on to item number 7, which is the manager's report. And we have the Rent Stabilization Manager, Jonathan Hollop, this evening with us. Mr. Manager, good to see you.
You too. Good evening, Chair.
And we're ready
Commissioners.
for your report.
All set. So for the look ahead, tonight, there's no appeals, just doing a review of some amendments to the RSO that staff is recommending that the commission recommend to council for approval. So I'll be giving a presentation on those amendments, and then we'll have discussion on that. February 9th, we've got an appeal for you. Also, a representative from the Coalition for Economic Survival will give a presentation. That meeting will also be remote. And then the February 23rd meeting is canceled because we don't have any agenda items. And you'll all be back in person in council chambers on March 9th. And I'm sure we'll have an appeal by that point. One announcement, very important announcement, on Tuesday of this week, the Board of Supervisors extended the county's tenant protection resolution through March 31st, 2023. There was a more ambitious motion before them, but the ultimate result was that the status quo will be in place through March 31st, 2023, which means a protection for tenants from no fault evictions. Some limited owner occupancy evictions will be allowed, and those tenants who are at or below 80% of the AMI can certify that they are unable to pay rent due to COVID-related impacts through the end of March. Some funding was also approved for Stay Housed LA. That information can be found once the funding goes through at stayhousedla.org, and we'll also put that information on the Rent Stabilization Division portion of the city website. If anyone, as I mentioned before, is facing eviction, and as I mentioned before, the tenant protection resolution does not stop eviction proceedings. The protections in there are available as affirmative defenses, so it doesn't stop the eviction proceeding from going forward. But if you're a West Hollywood resident and you find yourself served with a notice or with UD paperwork, unlawful detainer paperwork, eviction paperwork, please do call the division at 323-848-6450 or email us at rsd@weho.org. There's also information on our website regarding other rent assistance sources, and information coordinators can help with that as well. I'm available for any questions.
All right, thank you. Commissioners, do you have any questions regarding the report? I've seen none. All right, so we're going to move on to what's next is the commissioners' comments. Item number 8. Commissioners, Commissioner Martz, I see your hand.
Yes, I just want to share with everyone here and the public, the County of Los Angeles provided a grant to open the Hollywood Partnership Community Dispatch Center, and I believe it opened yesterday. Supervisor Horvath was there, and it is a dispatch center like we see at 911 with the screens and everything, and it is kind of a one-stop shop for tourists that need directions, for unhoused folks who may need help, or people who see unhoused folks who need help, to fill in some of the gaps that for a while we've been calling the police for, but may not be the best use of those resources, or they're not trained to help in these situations. So it's a $250,000 grant that's open 24 hours a day, 7 days a week, all year long. And then they're, I think after a year or a period of time, going to test it out. So it's on Spectrum News, ABC 7, everywhere. So if you want to check it out, I thought it was pretty darn cool to see.
Okay, thank you. Other commissioners, anything at this time? No comments? All right. So we don't have any appeal, and the next item would be on the agenda, item 10, new business. As the manager stated, we have the proposed amendments to the Rent Stabilization Ordinance. And the Rent Stabilization Commission will consider recommending amendments to the Rent Stabilization Ordinance to the City Council. So we're going to hear the report on this item with the recommendations, and then we will have a discussion. And I believe this item requires a vote, and there you go. So, Mr. Manager, this is your time.
Thank you. Let me share my screen. Okay, can you see that, Chair?
Yes.
Okay, very good. Okay, so tonight we're going to present to you proposed rent stabilization ordinance amendments. Just going through what is in the staff report. And the first proposed amendment is a prohibition on dog breed discrimination. This item was brought to staff by the council. It's a council directed item. Council directed staff and the city attorney to evaluate whether the city can prohibit landlords from establishing restrictions on pet breeds and rental housing. After reviewing it, staff determined that there is no barrier to enactment. There's no preemption issue. As some of you might know, and it was in the staff report, current scientific literature and the contemporary view is that breed is not determinative of dangerous behavior. The proposed amendment prohibits discrimination against a specific breed of domesticated dog in rental housing. And the proposed amendment still recognizes, however, that no dog may constitute a nuisance or a threat to the health, safety, or welfare of others on the property. I'm just going to go through the presentation and then I can take questions at the end. The reusable tenant screening reports amendment. This is an item that was brought to staff's attention by Commissioner Martz. Last year, the legislature passed Assembly Bill number 2559, and this established criteria for the use of reusable tenant screening reports in applying for rental housing. It's codified at Civil Code Section 1950.1. It allows for the voluntary use of the reports by landlords if it was prepared within 30 days of use at the expense of the applicant and available at no cost to the landlord. These reports allow a tenant to forego paying a fee for each rental application, which can run nearly $50 per application. That's set by statute. That's the most that can be charged, but obviously that will add up when someone is looking for a place to live in the area. But the bill specifically allows for local jurisdictions to provide greater protections to applicants. So that is what staff is proposing. The proposed ordinance mandates that a landlord accept what is defined in the amendment as a comprehensive reusable tenant screening report that is no more than 30 days old, and it contains the following information: the name, contact information, verification of employment, last known address, eviction history, criminal history, credit report and score, and the date the report was created. If all that information is in there, then the landlord would have to accept it. But the landlord can ask for an affirmation of accuracy for to make sure that it's still accurate information. For reports that do not contain all of the information I just mentioned in the comprehensive report, then the landlord is certainly allowed to accept a less comprehensive report, but it would be at their discretion. In either case, however, when a report is used, the landlord cannot be charged to view it, and a tenant cannot be charged by a landlord for using it or be charged an application fee. And if a landlord violates the provision, then they would be subject to an administrative citation. The next amendment is proposing an extension of section 17.56.010 sub H of the RSO to non-stabilized, what's referred to as new construction. The provision currently covers rent stabilized properties. Of course, that's most properties in the city. At the time of the enactment, there wasn't much new construction, and you could certainly say that it was new back in 1984, 85. But now that property, some of it is 45 years old, but it's still referred to as new construction. The subsection of this section covers these issues. It requires that properties of 16 or more units where the owner is not in residence must have an on-site manager. The on-site manager's business hours of at least 4 hours per day, Monday through Friday, must be maintained and posted. Buildings of 5 or more units must have an emergency contact number posted, and an on-site rental drop must be maintained if provided during the tenancy. For those first 3 bullet points, this is actually something that's already in state law under the California Code of Regulations. So it is already applicable to these non-rent stabilized new construction multifamily residential properties, but it was never integrated into the code. The regulations specifically allow for a local jurisdiction to integrate these provisions into their code and to be responsible for their enforcement. The final bullet point regarding rental drops, that's in sub H, and staff believes it should be included as well, as it's a tenant protection measure. It was something that the commission actually recommended to the council in 2021, and it was added at that time. And for equity, we believe that it should be included. The next section relates to an amendment to have administrative penalties for failure to register or re-register tenancies. So current law allows for issuance of citations for failure to register properties, re-register tenancies when required of non-rent stabilized properties. As the commission is well aware, the rollout of adding non-rent stabilized properties to the rent registry, the rental registry, is underway. Staff expects that that process will be completed by mid-year. In the provision that added this requirement, failure to register or re-register non-rent stabilized properties does subject the landlord to an administrative penalty. That was not the case for rent stabilized properties. It actually is not the case currently for rent stabilized properties. The current remedy is a prohibition on raising rents and payment of overcharges if the rents are raised without a registration or re-registration. You're all familiar with cases of that type where the landlord failed to re-register a property and was raising the rent during the period that it wasn't re-registered, and then oftentimes is an overcharge that is that the tenant gets as a result of those hearings. So this generally works, but not always. The reason we want to expand this is because it doesn't work in all cases. I want to point out that overall compliance is excellent. Most landlords have registered their properties. I anticipate that that will be the case with non-rent stabilized properties. The vast majority of landlords re-register their tenancies. I don't see why it would be any different with non-rent stabilized properties. But we have had some cases where, despite staff's best efforts, some landlords just will not engage in the re-registration process. Now, one could argue that, isn't there a remedy already? Well, there is, except tenants aren't necessarily going to know about it. And one of the reasons they know about it is because their tenancy is re-registered, because when there's a re-registration that occurs, the tenant is reached out to by the division and informed of their rights, and that their tenancy has been re-registered. So it's discouraging and creates a problem when landlords completely refuse to re-register even those rent stabilized properties that are already subject to it. So this would add the ability to administratively cite for those landlords that don't re-register their rent stabilized tenancies. There is, however, a provision of state law, Civil Code section 1947.7, that does put conditions on when a penalty can be issued against a rent stabilized property's landlord for failure to comply with registration requirements. The rationale for this is that, and this was a pre-Costa-Hawkins law, that sometimes it can be confusing about what's required, and the state legislature decided that there should be a period of time where a landlord can come into what they define as substantial compliance before any penalties can issue. So the amendments that are being recommended provide for this compliance period. It'd be a 15-day period in which the landlord can come into substantial compliance, as that's defined in Civil Code section 1947.7. If they still ignore the notification to come into compliance, then the penalty can issue. The staff's interpretation of 1947.7 is that it only applies to rent stabilized units. However, again, for purposes of equity and to also just err on the side of caution, staff is recommending that the requirements be applied to both rent stabilized tenancies and non-rent stabilized tenancies. So if a landlord, regardless of the type of property they own, fails to engage in the registration or re-registration process, then they will get a notice of deficiency, And if hopefully they will comply at that point, they'll of course be warned that failure to comply will result in the issuance of an administrative citation. And I would anticipate that most landlords will comply at that point. If they don't, then an administrative citation can issue. And the final amendment being proposed is a definition of principal residence. So this is necessary to clarify for purposes of exemption. Right now, there is an exemption for units that are occupied by a landlord or a close relative, and those close relatives are defined in the code. And if it is an occupancy by one of those people, then they won't owe a registration fee. It states specifically that the landlord or their relative is maintaining that as a principal residence. However, the code does not define what a principal residence is. And over the years, staff has found that that can lead to arguments over whether or not it's a principal residence or not. Adding the definition will also allow for the ordinance to be amended to put the term principal residence in the provision that describes the procedures for an owner-relative occupancy eviction, and specify that whether the landlord or their close relative is going to occupy the unit, they need to occupy it as their principal residence. So the definition it defines principal residence as the dwelling unit in which habitation is fixed, the person has the intention of remaining, and whenever they're absent, the person has the intention of returning. It also states that only one principal residence can be maintained at a time, and the factors to be considered when determining whether it's a principal residence is whether the person carries on basic living activities at the dwelling unit, the amount of time that the person spends at any other dwelling unit, whether the person is a registered voter at the dwelling unit, whether the person maintains utility services in their name at the dwelling unit, whether the person's vehicle registration, driver's license, or identification card contains the address of the dwelling unit, whether the person receives mail to the dwelling unit, and other relevant factors. So staff obviously sees an important reason for doing this and would like to make that change. So that is the end of my presentation. I can always pull the presentation back up again if something you want to look at, but I am, of course, available for questions.
Okay, thank you, Mr. Manager. Let me ask if the commissioners, I see Commissioner Wright is raising her hand. Commissioner Wright, please.
Thank you. Thanks, Jonathan. That was super, super helpful to answer some of the questions that I had when I was reading through it. Just some points, I guess, for more clarity for me. Which of the provisions that you've just sort of described apply to the non-rent stabilized units? Is it just the tenant, sorry, I'll let you just answer. I was I guess.
Because we apply to okay, so the on-site manager would add the other noticing requirements and the rent drop provision would add non-rent stabilized units. Those requirements already apply to rent stabilized properties. The non-discrimination of certain breeds provision applies to all to non-rent stabilized and rent stabilized units. Okay, and as I mentioned, the
Registration.
Sorry.
So just go ahead. I was just gonna make a comment.
Okay. So the registration requirement and re-registration requirement for non-rent stabilized units already has a penalty provision, but this would expand that to non-rent stabilized units and put in place the same procedure for issuing that administrative citation.
Got it. And then, so based on that, like, especially sort of regarding the on-site manager and like the rent drop and those issues, does that give, non-rent stabilized units sort of access now to, have their rent offset if, there's a violation?
No, the code currently provides for the division well, let me back up. Obviously, that is available to to rent stabilized units through this process, and the commission has seen those cases. Since there's no authority under Costa-Hawkins to regulate rents at this level, there can't be a reduction in rent for a failure to comply with that provision. But there's already this was actually added with a recent batch of amendments, allowing the division or the city to issue administrative citations for the failure to maintain an on-site manager or to engage in the posting requirements. So there is an enforcement mechanism if it's not adhered to.
Gotcha. And then with the re-registration, if a non, RSO unit, landlord's in violation, does that also activate the rent freeze if they aren't compliant when it's time for the increase?
No, again, it's for the same reason. At this level, of government, we can't do that. That's, there is some level of controls now because of AB 1482 for buildings 15 years or older, but so far that authority has not been granted at the local level. So the penalty, that's why initially the penalty was imposed, because in the initial draft of that ordinance amendment, so that there would be some teeth to it.
And then I'll let someone else go while I find my last two questions.
Let's go Commissioner Kirpis and then Commissioner Maggio.
Just to follow up on the discussion we were just having, but so the commission would not necessarily be involved through the appeals process in a non-rent stabilized unit registration issue.
There's opportunities for administrative proceedings for anything in the rent stabilization ordinance. So it's possible if, for example, the department initiated its own proceeding to do a fact finding, for example, and then that fact finding was appealed. More likely than not, however, it would just be done at the administrative staff level, because we would find out that a particular building that is required to register or re-register failed to do so. We do our own investigation and then issue the notice of deficiency. And if there still wasn't compliance, then either the division or the neighborhood business and safety division could issue a citation on the city's behalf.
But that would then, if they failed to pay those up for so much time, that turns into a criminal misdemeanor matter, right?
It could, yeah. The code currently allows for misdemeanor proceedings following the issuance of the first citation. It used to be 3 in a 12-month period. That was amended a few years ago.
Okay.
So it could be prosecuted. That's, a discretionary matter for staff and the city prosecutor as to whether or not it would go in that direction. But citations could continue to issue.
Okay. So, all right. In regards, so yeah, I think you answered my question. So in terms of the on-site management position, we are also not, as a commission through the appeals process, not involved in that as well, right? This would be also for the department to administer citations if necessary, all that.
Most likely, like I said, anything within the subject matter of the RSO could potentially go to an administrative hearing, what at one time was called a fact-finding hearing, and then what now we call a department initiated hearing. But even those are usually done to find out about whether there should be a rental reduction, whether re-registrations have occurred or not, and a rent overcharge should be issued. So I don't know what direction we'll necessarily go in if this is enacted in a particular case. I do foresee that it's more likely that it would be handled at the staff level. We do our own investigation. If it turned out that there's enough evidence to establish, for example, that there's no on-site manager, then a citation would issue. And then that's got its own separate process. A landlord
Yeah.
can appeal that, and that goes to a hearing examiner, and the commission would not see that. Because
Okay.
that then goes on to Superior Court if they want to take it further.
Yeah, I just want to make sure I understood the process, what we're doing here, and where it would affect us, or where we would most likely see an issue is, let's say it was a rent stabilized unit that now not only has to have the on-site manager, which we've always required anyway, and we sometimes hear appeals that, you know, rent reductions in that area, we might hear a case similar to what we've heard in the past, but in addition to our hearing the appeal on whether there should be a rent reduction, there might also be facts to the case that they're also receiving a administrative citation because they don't have a rent manager on site, but not necessarily, kind of like when we see other code violations in our cases. We don't really decide those code violations, but we do, it may affect the tenant's request to for a rent reduction, right? Okay.
Correct.
And I think that was the only, did we get any feedback or have we sought any feedback from landlords on the issue of using the common, I don't know what to call it, let's see, it's the second issue that we're deciding tonight, regarding the background checks or the credit checks. Have we gotten any feedback on any concerns that landlords, I don't recall when this was in the legislature what the main concerns were, but have we had any feedback from our landlords about what their concerns might be over requiring them to do it this way?
Nothing yet.
Have we made any attempt, or would landlords know necessarily that we're even doing this other than our agenda?
This is the first public hearing on the topic, so they'll know about it, and they'll certainly know about it when it goes to council.
Thank you.
Commissioner Maggio, please, you have questions?
So a couple of things here just for clarity, Jonathan, in regard to penalties, penalty for non-registration. We know the first step is a citation. What would be the ultimate penalty? Would that be a dollar amount?
We have, once the ordinance passes, if it passes, then staff would make a proposal to council in the fee resolution that is adopted usually in May, that would establish the penalties for any of the things that are being adopted that would be subject to an administrative citation. So there's no dollar figure yet, but it gives the city an option to establish one.
Okay, my second, I'm waiting for the siren to go by, sorry. My second question in regard to posted signs and hours, etc., which has always been one of the regulations. Where are we redefining that here? Because it's already been a regulation.
No, there's no redefinition. It's just that, and I'm not sure why, but these requirements were not made for new construction back at the incorporation of the city when the rent stabilization ordinance was first adopted. I mean, my conjecture is that at that point there wasn't much new construction and it just wasn't considered an issue. Now, obviously, there's a significant number of units have been added since 1979, and those buildings of 16 or more units are already required under state law to meet that requirement and the emergency number posting. So it's just bringing those properties into the fold within the city's law. And that would allow the city to engage in enforcement, which is specifically authorized by state regulation.
My last question is in regard to drop-off boxes.
Mhm.
Do we know if we've ever had problems with that? Like, for instance, I've put my check in the drop-off, but it wasn't received. To me, it's always better if you can to hand someone something.
Yeah.
Is there any way perhaps we can strengthen that or help that if there is a problem?
I don't know how the purpose behind that, the genesis of that requirement. I can't remember if it came from staff or the commission. I know that staff has, particularly in cases of allegations of tenant harassment, has heard about situations where there was a drop box and it was removed, and then it became more problematic actually through the mail to make sure that the landlord got it. There was potentially denial of it being received, whereas the tenant used to have no problems when they could just drop it with an on-site manager in a box at the property. It'd be hard for the city to monitor every single drop. But, I know people have recorded themselves dropping it in the box. Now everyone can record everything. So they record it, the actual physically dropping the rent in the box or in the mail. I don't have any specific ideas for you right now, but that's the genesis of it. And I think that what the tenants who were complaining wanted most of all was to make sure that if that was a housing service that had been granted during the tenancy, that it not be taken away. So that's why it's there.
All right, thank you very much.
Welcome.
Thank you, Commissioner Martz. Anything? Commissioner Wright, you want to go with your remaining questions? Because I have couple of questions also.
Yes, thank you. And then to Commissioner Maggio's point, just about the rent box, it's interesting. I'm in a rent stabilized unit, but we're having an issue with our drop box now where, all the years that, some of the long-term tenants have been there 30, 40 years, they've been able to drop their rent in the rent box at any time, on time or late. And now, our building, managers, they close the box or tape it so you can't actually drop your rent if it's late. And the only other option is you have to take it physically to the office in Los Angeles. And so there's, just one example, I think, of some of the rent box issues. But the two questions that I had remaining was, it'd be easier if I was not using physical paper. Oh, the provision regarding the application fee for those reports, does that essentially sort of do away with tenants or applicants having to pay anything that's sort of termed an application fee? So, if it's $75 application fee and maybe 50 of it's maybe used towards that, the additional 25 is just whatever fee the landlord's tacking on, does this sort of do away with tenants having to pay any application fee as long as this report is submitted and it meets the other requirements?
Yes.
Okay.
Mm-hmm.
That's awesome. And does that also, does that apply to RSO and non-RSO units?
It would apply to both types.
Okay, got it. And then the other one is just more of a question about how it appears in the regs. And subsection D of the reusable tenant screening report, if you have the physical one, it's page 19. And in subsection D, it just says, if an applicant provides the landlord with the reusable tenant screening report pursuant to subsection C or D of this section, should that be pursuant to subsections B and C, not C and D?
Thank
okay.
you. That's exactly right.
And no more questions. Thank you so much.
Appreciate that.
Thank you. Commissioner Purpose.
Real quickly, I just wanted to clarify and ask if this is correct. It was my understanding that just out of the conversation we were having, it's not relevant, I think, specifically to what we're in front of us, but just to clarify, landlords are not allowed right now to charge anything more than what it costs them to run an application, right?
Right, and even that is statutorily capped.
Okay.
It's close to $50. It's $50 and some change at this point.
Commissioner, right, if anyone owes you any money, you better contact them.
Thank you.
Okay. All right. Thank you, commissioners. Mr. Manager, just a couple of things. I had some questions about the registration, but the commissioners already asked those questions and you clarified. Thank you for that. Regarding the reports, in your slide, it said the Civil Code section 1950.1. It mentions that the state law allows voluntary use of the report by landlords. While the ordinance language, it says the ordinance mandates that the landlord accept the report that is prepared within 30 days. Would that be in conflict with the state law, or because it seems like the state law says it's voluntary for a property owner?
Right, and then there's another provision in the state law that specifically states that if a local jurisdiction enacts a similar scheme with greater protections, then the provisions with greater protections applies.
All right. Okay. That clarifies. The other question about the posting of those on-site managers hours regarding the managers, on-site managers for these new constructions. In the RSO, we have very specific and very actually specific requirement that has to be a specific hours between 8 and 5, the reasonable hours and everything else. Will this whole thing apply to the non-RSO new constructions also? Would that be, I just want to understand that, so that the posting would say this person is available at this number from, for 4 hours at least.
Mhm.
Okay.
Yep.
All right. As I said, I have no questions about the re-registration, but I have one question about the penalties maybe, or I don't know, we'll call it consequences for these bad faith evictions if they occur. This is about the owner occupancy. That has to do with the definition of a principal residence. So when a landlord applies for owner occupancy eviction, files with the department, the landlord, this is a question, is the landlord required to identify the person who will be occupying the unit?
Yes.
Okay. And so this means that that person that specific person has to move in, and that person will become a principal resident. That's the understanding. And if that doesn't happen, what is the mechanism? How the department will monitor? And if that doesn't happen, what will be the penalty or consequences? If you can just briefly explain.
It could be any number of things. One consequence is obviously between the parties themselves, is that the prior tenant can certainly sue their former landlord. Another consequence is that the city could seek an injunction to return the prior tenant to the unit. Another consequence, if it was a bad faith eviction done not to necessarily put somebody who's living in there part-time, but it was just fraudulent to get out a prior rent stabilized tenant and raise the rent to market, then another consequence would be that the tenant that moved in would, their rent would go back to whatever the rent was when the prior tenant was evicted. Obviously, that's not necessarily an ideal remedy for the tenant who had been evicted, but it would depend on the circumstances of the case. It would depend what the former tenant wanted. It would depend on what the city can provide. I know that there have been cases throughout the city's history of an administrative determination being made that, because of that kind of bad faith eviction, that the new tenant had their rent drop down to the whatever the prior tenant's rent was. But so there could be consequences for sure.
There could be consequences. So I think this is really it's a good time. It's a timely kind of a change or a amendment to the RSO, because once the emergency is over and the evictions are allowed, we don't know what might happen. This will provide like extra protection or that comfort zone for the department to monitor and to see if the evictions are legit.
Mm-hmm.
Now, my concern though is if somebody, again, I don't know if this relates to this particular thing. If the landlord reports that this person, my son, hypothetical, my son moved in and he's a principal residence and here's the utility bill, but then I re-rented and I set some crazy market rate rent. So what is the mechanism for the department, or how would we even know that happened? Because the landlord submitted a copy of the utility bill and a Bank of America statement that shows, Agus's son is there, but so how is there any tool or any mechanism how we monitor and look into that?
Sure. Well, one thing that can happen, I'll just say this right off the bat: we do monitor properties where this happens. So we check as a division, and if there's any question, we'll go and knock and see who lives there.
Okay.
And another way that this has been discovered, or in various situations, is the new tenant in your hypothetical, the non-son tenant will come in or now online apply for a parking permit, and we'll discover that name doesn't match the name of the person who supposedly moved in.
Okay.
That's been a big giveaway.
Oh yeah, I forgot about that part. So I think that's another way of checking. That's good. Okay, thank you, Mr. Hollow. I don't think I have any questions as we covered everything else. Commissioners, are there any other questions regarding this report, or Commissioner Martz?
I just have a comment, not a question. Mr. Holland, thank you for bringing this. I know that I've spoken about this topic, especially the applications before, and I've seen it floating around on my all too often time on Twitter about people that have, spent upwards of $1,000 sometimes applying for apartments, and especially, at any income level. I think that's ridiculous. So I think this is actually going to be a meaningful change for our residents. And, sometimes the work we do is a little bit pie in the sky, and, we don't have a lot of public comments, but I think we can, all of these changes will have a meaningful impact on the daily lives of the people that live in our city. So I appreciate you bringing this forth, and I hope the city council passes it.
Thank you.
All right, thank you. All right, commissioners, I believe we need to make a motion and take a vote on the recommendations, since there are no suggestions or recommendations to change anything that we heard today and what is before us. Anyone would like to make a motion?
I have a question. Do we need to, if we pass it with the language that the sections will be changed, or is that just an administrative note? We just need to pass it.
I'll just make the changes. You're voting on the substantive, and thank you again for catching that.
Okay. All right. Move to accept the provisions and amendments that we've just discussed.
Okay. Do we have a second?
I'll second it, but can we change the wording of the motion just slightly? that we are actually recommending this to the city council, because I think that that affects the outcome potentially. I mean, I don't think this council will have any problem passing this, but or addressing this issue. But I think if we pass it as a recommendation of a policy, it has a different effect.
Right, that is what it says, recommendations to the city
okay.
council. Yeah. Yeah.
And I do second it.
All right. Okay, yeah. So we have a motion, and we have a second on the proposed amendments to the rent stabilization ordinance to recommend to the city council to approve the proposed amendments as we heard tonight. And that is included in our packet today. Any further discussion on this motion? I've seen none. Ms. Secretary, may we have a roll call vote, please?
Commissioner Kirpies,
Aye.
Commissioner Maggio, Commissioner Maggio,
Aye.
Commissioner Martz,
Aye.
Commissioner Wright,
Aye.
Chair Topshin.
Aye. Motion passes and we approve these, recommended the amendments. Thank you. Mr. Manager, this was a very comprehensive and really good report, easy to understand, and thank you for your presentation. Appreciate that. And thank you to your staff who behind the scene working obviously hard to implement this, to make this come true, and thank you. All right, so don't go away. We have the next item on the agenda, which is items from staff. Anything else, Mr. Manager, from your department?
Thank you, Chair. Just reiterating the division's number in case anyone has received anything related to an eviction or a notice threatening eviction, 323-848-6450 or rsd@weho.org. Thank you.
Perfect, thank you. Okay, let's go on to the public comments. I don't know if we have any speakers at this time, Ms. Secretary?
No speakers at this time.
Okay, no speakers. Item number 13 is the commissioner comments at the end of our meeting. Commissioners, would you like to make any comments at this time? Commissioner Kirpies, please.
Just to reiterate what you already said, Chair, to thank staff and all their work on this item. It's very important, and as Commissioner March said, this is going to affect people's lives in a positive, meaningful way. And so I just want to thank staff for bringing this to us and all the work they did to present it as easily to understand as they did. Thank you.
Thank you. Other commissioners? No comments? All right, so then the last item is the adjournment of the meeting, and the next meeting of the Rent Stabilization Commission will be held on Thursday, February 9th, 2023 at 7 p.m. via teleconference. Thank you, everyone, and good night.
Thank you. Good night. It looks like Commissioner Wright is in the matrix, but I think I see a goodbye.
All right.
Good night, everyone.
Good night.
Good night.